Take it away, Wes.
All right. Thank you, Mr. Chair and Board. My name's Wes McLeod. I'm the Local Government Services Director with Cape Fear Council of Governments. We provide these trainings to planning boards, boards of adjustment, and also elected boards concerning planning and zoning development regulation. So thank you for having me here today. We got a bunch of material to cover, but before that, if you don't mind, I'll just going through and providing a brief introduction and also include your tenure on the board. I know we've got a couple members that have been here a while, but some newer members, and if we can start at the end there.
Oh, me? Sorry.
ma'am. You're
Good
okay.
morning. I'm sorry. My name is Sue Stewart. I'm brand new.
Okay,
I mean, we're talking still eggshells behind the ears
got it.
kind of deal.
10-4.
So, but yeah, live here, love this place,
Okay,
and I'm trying to learn more.
okay,
Nancy McMurray, and I am also new. I'm an alternate.
okay. Beautiful.
Those are ultimates. I'm Chairman Farley. This is Vice Chairman Steve and Ed
Yes,
and John.
yes. Did you want any further information?
Yes, and then John, have you been a member for a while or?
First term,
First term?
Yeah.
Okay.
Second term.
Second term, okay.
and this is my second term.
Second term, okay. And so, John, have you had a meeting yet with cases or not yet?
Oh, yeah.
Okay,
Yeah,
okay,
they got me right away.
okay,
It didn't take long.
okay. And then our other two members, Nancy and Sue, you all,
Alternates.
and have you been present for any meetings with cases?
Yes.
Okay, great. So you guys at least understand generally how these things work, but we'll go dive into the details about procedures. And I will say that, just please interject if you have any questions along the way. Okay, so just to get started, I think it's always important to understand our legal context for our local governments, and that our local governments are creatures of the state and they have no inherent powers. And then across the U.S., there's two different types of states, one being home rule states and the second being Dillon's rule states. Also, this material I'm sure can be printed for you guys, so don't feel like you need to take copious notes, et cetera. Home rule states, the local governments have very broad authority. Basically, they can enact any rule, ordinance, or law that doesn't violate the state or federal constitution. Dillon's rule states can only do those things that are granted to them by their state legislature. So they have much less authority overall. North Carolina is a hybrid of those two. And so, we have been granted a significant amount of authority. But one thing in particular where our authority seems to be clawed back fairly regularly is related to our planning and zoning authorities. And so, you see that in preemption bills, or for example, just our neighbor over in Southport, there was some things that occurred and their ETJ was stripped away. And so that is a perfect example of our legislature reminding our local government that, hey, you guys don't hold the cards, we actually hold the cards, and if we think that you're acting outside of your authority, then we can pull those cards right from you. And then in particular, as it relates to Board of Adjustment, one thing that is effectively entirely regulated by state law is the function with which you issue variances and hear appeals. And so it doesn't matter if you're in the town of Black Mountain or here in Oak Island, if you're going to hear a variance, the same criteria take place. Does that make sense?
Wes, can I
Yes, sir.
ask you to speak a little closer to the
Sorry.
mic?
Yes, sir.
I
Yep.
got my hearing aids turned all
That's
the
okay.
way up.
The same problem.
Yeah, they need an extension on this thing. Okay, thank you. All right. So that just provides a bit of foundation for everyone and understanding why it's important. to not act outside of our authority specifically. So second thing we'll get into is the 4 types of land use decisions. The first is our legislative. These are policy decisions that include adoption, amendment, or repeal of regulations. These are things like when anytime the zoning code, or UDO in this case, is amended, that is a legislative decision. It's a policy decision based on the input of also citizens. There's a legislative public hearing that occurs. Folks may show up and say, no, I do not think that you should raise the maximum height limit for residential structures, for example. But if the elected board believes that's appropriate to do so, they may, in fact, enact that rule or law. I'm not suggesting that that's going to happen, but that's just an example. Also, adoption of the budget is also a legislative decision. Those decisions are always going to be under the purview of the elected board or the governing board, in this case, the town council. Second is advisory. These are not final decisions, and in which case they are therefore less regulated, and they're typically a function of the planning board or staff. These are anytime there's a recommendation on a plan or a text amendment, there is, effectively nothing that occurs here. So if someone's displeased with an advisory recommendation, they can't, appeal it to the Board of Adjustment because nothing has actually transpired. Third is administrative. These are your routine activities, are typically handled by professional staff, but sometimes by a planning board or governing board. Examples of this are when Brady, for example, issues a zoning permit or a sign permit. Someone applies for one of those zoning permit or sign permit and meets the terms of the ordinance, the local government's bound to issue that approval. That also goes for plats as well. So subdivision plats may sometimes be under the purview of a town staff member, but they may also be the responsibility of a planning board or a governing board. The key with administrative decision is if I apply for a zoning permit and Brady is to deny my zoning permit and I feel as though it should have been issued, then I can appeal his decision for denial of that administrative decision to the Board of Adjustment, and in which case it would come to you all. That's a key distinction there. And I'll point out the difference, for example, is say I'm a citizen and the town approves a rezoning and I don't like it. I cannot appeal that decision to the Board of Adjustment. You guys basically don't have the authority to overweigh the elected wisdom of our council, for example. If someone is displeased with that legislative decision, they've got to file some type of separate court action. So appeals of administrative decisions are the responsibility of the Board of Adjustment. We'll talk about it in more detail. Last are quasi-judicial decisions, which are the procedure in which the Board of Adjustment functions. These are formal actions where the decision makers apply discretion in existing policies to individual or special cases. Quasi-judicial basically means it's a court-like decision based upon an evidentiary hearing to gather facts and evidence and have very specific requirements. Quasi-judicial decisions are special use permits, variances, and appeals. Decisions for each of those items can be the responsibility of the governing board, planning board, or Board of Adjustment. Although I'll say that the Board of Adjustment is always going to be the board that hears a variance or an appeal. Some of our local governments, the planning board has 2 functions. They also function as the Board of Adjustment as well, and so they have dual roles. Luckily here, we have a separate board that hears those. Questions about any of those 4 decision types?
I have a question.
Yes, sir.
And it's subdivision plan approvals, not plat approvals, but plan approvals. In Oak Island, that is the town council that approves those.
Yep.
In Brunswick County, it's the planning board that approves those. So it would seem that, I mean, in both cases, I think that's really not a legislative decision.
It's not.
So, if someone was aggrieved by that approval, would that appeal come to a Board of Adjustment?
So that's a great question, and I did not touch on that topic. So first off, I'll talk about Oak Island. It is an administrative decision in front of the governing board for that subdivision plat approval, and there's a particular statute that states that when subdivision approval is specifically before a governing board or planning board, the appellant may go straight to Superior Court and bypass the Board of Adjustment. In Brunswick County's case, they actually have special legislation to hear what are called PD approvals, plan development approvals, that are rezoning cases, and them and City of Charlotte, and there's a handful of others that have special legislation for the planning board to hear legislative decisions. And so even though it's the planning board, if someone is also upset about what goes on at the Brunswick County Planning Board, and if it is a PD rezoning, that still would go, that would have to be a separate court action, unless it was a straight up subdivision plat that is under an administrative approval process. Similarly, would go to Superior Court.
Thank you.
Did that answer your question? Good question, though. And I'll just add that, subdivision approval as an administrative decision-making for our elected boards is sometimes problematic because, I'm a property owner. I apply for a subdivision plat. It's, let's just say, 50 lots, meets all the minimum requirements. But inevitably, the neighbors are going to say, what? I don't like this. You should not approve this. And me as an elected official, I want to listen to my constituents and align with their concerns. But if I disapprove a plat that meets the terms of the ordinance, and me as a property owner who filed it appeals to Superior Court, the judge is immediately going to say, you acted inappropriately, and will remand that subdivision plat to be approved, or they'll approve that subdivision plat right there in court. And this is an issue that happens across the state. Columbus County recently has had this issue, so it's a difficult thing. Great question, though. All right, so you'll see there's going to be a bunch of statutory references here. You don't need to remember these or know them. I'm just providing them to you so you've got some basis for why it's important to follow certain procedures. So GS 160D-302 establishes the Board of Adjustment. It has to be 5 members minimum, appointed to 3-year terms. Alternates can be appointed, quasi-judicial procedures required. And I mentioned this prior. The planning board may function as the BOA, but in that event, the planning board, say they had a Board of Adjustment case, they would actually close their planning board meeting and then reopen. They put their Board of Adjustment hats on and then reopen as a Board of Adjustment to hear that case. In Oak Island, your duties as the BOA, Board of Adjustment, are to hear appeals and authorize variances, and we're going to talk a little bit about both of those specifically. And Brady and Lisa, also please feel free to weigh in should something come to mind. As a result of the enactment of Chapter 160D, there is now a provision that specifically defines and establishes a procedure for staff determinations of development regulation provisions. And so, and these can be appealed to the BOA as well. So if an example of this is, say, I'm a property owner, I think my setback is 7 feet. Brady, as staff member, believes it's in fact 8 feet or 10 feet or whatever it may be. And so you know, I say I want an official determination because I want to be able to get a final decision or interpretation from the Board of Adjustment. So I can seek from Brady, please issue me an official determination that I can appeal that to the Board of Adjustment. Brady would write out a letter that says for, you know, these particular reasons is your side setback is in fact 10 feet and not 7. I can then appeal that determination to the Board of Adjustment, and then ultimately you guys would have to decide based on the facts and evidence presented whether the setback on my property is 7 feet or 10 feet based on this, on what the staff interpretation is. In years past, the Board of Adjustment had the authority to offer initial interpretations, but now the legislature has said, hey, wait, let's let staff make a first determination, and then that decision can be appealed to the Board of Adjustment rather than you guys trying to sort out what the initial determination should be, if that makes sense. All right, we'll talk about appeals first. And if you guys, I don't believe have heard many appeals. Okay, yep. I was gonna say, I can't recall any that I've been privy to. Okay, but we'll talk about them anyways. Appeals of advisory opinions are not allowed. A case must be the appeal of actual official staff determination or action. When interpreting an ordinance, the Board of Adjustment must determine the intent of the governing board in regards to that particular provision, if in fact it is not plainly clear what the rule is by its plain reading. This would potentially require some minutes, things of that nature, possibly staff reports going back to whenever, if they're available, that particular provision was put in place. This is a key one here, important. An appeal must be brought by a party with standing. In other words, they must hold a property interest as specifically affected by the decision within 30 days notice of decision. This may also include a neighbor appealing the issuance of another neighbor's permit, which has been occurring with greater frequency across our region for various reasons. And so I will just quickly give you a little thought on that. Let's say that someone is building a house down here in Oak Island, and me, I live in Wilmington, and I happen to drive by, and I don't like it, and so I call Brady and say I'm going to appeal the issuance of that building permit. I don't believe it meets the terms of the ordinance. Well, Brady will say, well, thanks, Wes. I'm sorry you're upset. You live in Wilmington. You probably know you don't have any standing to bring this case before the Board of Adjustment. I would tell Brady, well, Brady, that's correct. However, you know that you're not allowed to make that determination. And so he would have to allow that appeal to go forward to the Board of Adjustment. And you all, now having a training, would know that we can't hear Wes's complaints and appeal regarding the issuance of that permit. However, if I was a neighbor, there's probably pretty good reason to state that I would have standing to appeal the issuance of that permit. Obviously, if the permit was issued in line with all the terms of the ordinance, it doesn't much matter. I would have had to pay the fee and waste everyone's time to hear that appeal. But the key being, it has to be brought by someone with standing.
Has there been any interpretation or anything suggesting when that 30-day notice begins to run? I mean, obviously for the applicant, it would be when the staff decision is made. But for a neighbor, that may not be.
Yep. And if they don't know, they don't know. And so if I don't know when the permit was issued, then I'm out of luck, right? And so when this occurs, typically someone is on notice. And what happens is there'll be public records requests, saying, I want to know, when was there a permit issued for this property, et cetera, et cetera. They'll be primed and ready to,
Right, but I'm just thinking from a Board of Adjustment standpoint, a neighbor may not know of a decision that was made until some actual activity on the property begins, which may be well after.
yep,
So from a Board of Adjustment standpoint, do we look at notice as being the time at which the neighbor actually has notice, which would be at the time that the activity begins? Or do we go back and look at when the decision was made by the staff?
So there's two things here. One, if I'm actually appealing the issuance of the initial permit, because I believe it was issued in error, it has to be within 30 days of its issuance. Alternatively, and this is what sometimes happens, say it's in process of being built, the permit got issued 6 months ago, I think that the pilings are too close to my house. I can ask Brady for an official determination to that effect and say, I think that these are in fact, they're not in compliance with the 10-foot setback. They're 7 feet from my property. And he would be bound to issue a determination, which then I could appeal to you outside of the issuance of the permit. And so long as I applied for an appeal within 30 days of his determination, then it could
So
come.
it would be incumbent on the neighbor to come to the staff and say, is this correct?
Correct.
Okay.
Yep.
And that's where we, as a Board of Adjustment, would judge whether or not that occurred.
Right. That's right. I mean, this, in other cases where this has come up, like I said, there's been a handful of them, the neighbor is sending an email to the clerk daily. It's because they know that a permit is going to be issued. They've had public records requests. Lisa, is like, please don't tell people about this. And, as soon as that permit gets issued, then they file an appeal. I mean, this is not common, but I'm just providing some reference.
So should the neighbor not know, he's just out of luck?
That's right. And remember, I mean, you as a property owner, you have certain rights, right? I don't need to notice my neighbors unless I'm required to do so because I've got a special use permit on my property or some other legislative action. If I'm just building a house and I'm permitted to do so, I don't need to tell anybody.
We had an occurrence probably 10, 15 years ago that a neighbor was adding an addition to his house, a porch, and all the neighbors had to be notified and approved. Is that still in effect?
So that would, in that instance, my guess is there was some type of action that occurred that required notice on the property. They were asking for a variance, most likely, or something like that. Or there was some type of rezoning. That's the only event that notice is actually required. You can voluntarily tell your neighbors that you're getting ready to, build a house and block their view or whatever else, if you want. But, yes. So, yes, and if you are in an AEC, and thank you for interjecting there, if you're an AEC or you're basically oceanfront or soundfront or intercoastal front, you do have to notice your neighbors when you're pulling a CAMA minor permit, which is not the same as any typical zoning permit. But that authority doesn't lie with you guys. Now, they may then be aware that another slate of permits are getting ready to come down the pike, which then they could appeal to you all regarding zoning. But for CAMA, that would be under the purview of Division of Coastal Management. Thank you.
All right, one more thing about.
Yeah, sure.
I don't know how much more you're gonna do on appeals, but
We got a couple more, but you're good.
I have seen a number of cases come through where people have asked for variances when it probably would have been more appropriate for them to appeal the initial decision.
And so, as staff, we can provide to you as a citizen, applicant, developer, property owner, et cetera, the distinction between the two. But we cannot say that you have to do one or the other. And so what often happens is they understand, okay, well, I can appeal this and maybe I'll be correct, or I can just straight up ask for a variance. And if I'm granted the variance, the entirety of the issue is resolved because I've been de facto granted permission to do whatever I want to do that's at odds with some type of interpretation. Is that?
Yeah. Unfortunately, it seems that, at least from my perspective, the conditions for granting a variance may be sometimes more difficult than finding or approving an appeal, basically overriding a staff decision. So there's that too. And I guess what I'm reaching for is there any way, and I'm guessing your answer is going to be no, but is there any way at the time that comes to the board, that case comes to the Board of Adjustment, for the board to say, look, you're not, this is not the right thing?
Unfortunately, not really. I mean, if it's not the right thing, meaning, if the variance doesn't meet the terms, they're not granted the variance, right? It's kind of what it boils down to. You can provide some feedback to that, but, really, as the board, you're bound to hear their case. That's, and not necessarily tell them that they should do one thing or the other. That's what you guys are here, and you get paid the big bucks to listen to someone's petition.
Can both be done? Can they appeal and do the variance? And the
some-
reason why I'm thinking that is, being on the board,
Yep.
if it's already been appealed and it was denied, and now there's the variance, do we have the ability to review that? Do we have the ability to see that, or are we looking at something brand spanking new?
So, I mean, they
That's two
have to,
parts.
they have to file for each of those separately. And so if their appeal is, not overturned, they don't overturn the decision that they want, and they then apply for a variance, you then need to hear the variance. It is, we can't necessarily interpret the statutes for them. We can provide them the information. We can't tell them, people always say, do you think I'll be granted a variance? You think I'll get it? I can't tell you that. I'm not the Board of Adjustment. And frankly, I'm not in a position to be able to offer you that advice.
But let's say they wanted to appeal it.
Yep.
And it was denied.
Yep. Then there's going to be some history there a little bit.
Do we have access to that history, or do we not? Because, I mean, we don't usually get a packet we don't get the case until the day of.
Sure.
Or a couple days of, and we're really not permitted to.
We'll talk
We
about
have
that too.
rules.
Yeah, you should not go on a fact-finding mission.
Right, exactly.
So you may, but I think, remember, you are supposed to hear the case based on the evidence that's presented at the meeting.
Is that not evidence, though?
It is, but if it's not presented, again, you're not necessarily the person that's to be out gathering the information.
Agreed. So that would mean that if the staff did not present that, if the staff did not include that in their side of the case, then we're just
Probably
dealing
not.
with what we have. Got
Yep.
it, okay.
Yep,
So
and
it's not within the purview of the staff to recommend either way, he's just to acquaint them with the facts.
correct. It is not within the purview of, I mean, there are some local governments that staff may offer a a recommendation, but I believe that that's at odds with the conflict of interest provisions because you guys are not supposed to have a fixed opinion prior to the hearing. So me as a staff member, if I tell you guys that I recommend approval of this variance, how is that? That does not, that impacts your opinion when you're walking in the door to hear it. And if you're a neighbor that's, displeased with this, yeah, I feel like you've trampled on their rights from the get-go. And you guys don't offer recommendations on these. Yep. And so please do interject here if I'm saying anything at odds with. Okay. That was my, yes, ma'am.
Would we be able to request at the time of the hearing, can we request if there was an appeal?
I mean, you can ask the question, but again, you're starting to get into towing the line of, just hearing the evidence versus,
Fact-finding,
yep.
got it.
Yeah, typically, they would say we declined to make a comment on that. And I've seen that kind of thing done.
Sure. Yep. It depends if they've got representation or not.
Yeah,
Yep.
the attorney's gonna say,
Yep.
So what's the point of asking questions if it's not?
No, I mean,
finding?
no. And I guess that's a great question. I mean, you are supposed to be helping to determine the facts of the case, but I guess you should not be necessarily in the process of trying to uncover new evidence, right? Does that make sense?
But we could ask that,
Yeah, you could ask that.
okay?
Good to know.
An appeal must be heard in a reasonable time and notice is required. There's no stipulation that you guys have to meet in a certain time period. The official whose decision being appealed must provide relevant documents to the board, and the appellant must be present at the hearing. The board may reverse or affirm in whole or in part the appealed decision. So basically, you have the responsibility of whoever that official was when the initial decision was made. Usually, you're gonna, reverse or affirm the decision. You're usually not gonna modify it, only in the event there's some type of, I've seen where there's, the setbacks are based on the average of the, all the lots on the street or whatever it may be, and the initial setback was established at 12 and a half feet. You see some evidence that it should be 14 and a half feet or whatever it may be, but usually you're gonna uphold or overturn that decision. Parties may agree to mediation or some type of other alternate resolution outside of the hearing. But if that happens, you guys wouldn't know about it. And then this is another provision in 160D. Except in questions of interpretation, a person with standing may now bring an original civil action to challenge the enforceability, validity, or effect of a local land development regulation. In other words, if they believe that the rule violates the authority or it's unconstitutional, they can just go straight to Superior Court. Okay, we'll talk a little bit about standing. Any person who has standing or the town themselves may appeal a decision to the Board of Adjustment. That would be the owner of the property or someone with an option to purchase or lease the property, an applicant for a development approval. The second one is the difficult one. Any other person who will suffer, quote, special damages as a result of the decision being appealed. Excuse me. This may include parking, stormwater runoff, and crime problems, or property value impacts. And then proximity alone is not enough to prove that they're suffering special damages.
Special damages, that's a nebulous term.
It is a nebulous term. It has to be it has to be based upon evidence that's presented at the hearing, if in fact you believe that they are not meeting the requirements for standing. So really, if there's a question of standing, that can be made by you all, or more likely, or advisably with the counsel of your attorney. That'll be present. Hey, this person, they live a block away. That they're appealing this. Maybe they're going to have some road impacts or traffic impacts. They haven't brought us any evidence to state why they're going to, suffer property value impacts or other type of impacts, with the exception of they think that traffic's going to increase. I don't know. That's pretty loosey-goosey.
But they would have to have some substantial backing to support that.
Correct. Now if they had an appraiser's report under seal that says their property values are going to be substantially impacted, if they had an engineer present that said that they're going to have, a bunch of stormwater drainage issues, or if they had a traffic engineer who also was stipulating and providing evidence to you all that there's going to be some negative external impacts to them and their property, then that's probably reasonable to state that, they may have, quote unquote, suffering from these special damages.
And then they have to convince the Board of Adjustments as such.
Correct. Yep. In general, if you're a neighbor, it's pretty good likelihood, I would say. Number 3, an association of neighborhood property owners that would be affected, provided that at least one of the association members would have standing as an individual, and that the association was not formed in response to the particular application being appealed. And then number 4, of course, is the unit of local government that has made the decision being appealed. All right. Standing is also important for participation of third parties in any other quasi-judicial proceeding, anyone that wants to provide testimony, for example. All right. Yes, sir.
When it comes to making a decision on standing, it is up to the chair to make that decision.
Correct. Yep. Yep.
It's not really up to the board to discuss per se.
The board, you all can discuss it. You're not prevented from doing so, and I don't believe that you're necessarily prevented from bringing it to a vote if it got to it. That really is ultimately a legal question. So if you have your legal counsel present, absolutely should be a question for them before, you're going to render some type of decision to that effect.
You mentioned having the legal counsel present. I've often wondered about that. Should the legal counsel be leading the board or making suggestions on way to do things or how to solve a conundrum? Or should the legal counsel only give an opinion when the board asks him?
Well, it really depends on the local government and the local government attorney that's involved. I think that being a little bit proactive doesn't hurt if maybe the attorney feels like things are going procedurally in the wrong direction. But really it is the board's meeting and there's an advisor present, if that makes sense. But I'm not here to step on anyone's toes on how things, unfold. All right, let's talk about variances. We will talk a little bit more about standing and evidence as well, but we'll go through and jump into variances. So the particular criteria for granting a variance are outlined in Chapter 160D-705D, and it gives the board permission to modify any provision of the ordinance to prevent unnecessary hardships where they meet 4 criteria. And I'll say modify, I mean, think about a variance. You are varying the terms of the ordinance. You are not rewriting them. That's, a good way to think about it. 1, unnecessary hardship would result from the strict application of the regulation. It is not necessary to demonstrate that in the absence of the variance, no reasonable use can be made of the property. Number 2, the hardship results from conditions that are peculiar to the property, such as location, size, or topography. Hardships resulting from personal circumstances, as well as hardships resulting from conditions that are common to the neighborhood or the general public, may not be the basis for granting a variance. And this has been added more recently. A variance may be granted when necessary and appropriate to make a reasonable accommodation under the Federal Fair Housing Act for a person with a disability. So we had a local government recently, a woman, they had a dog that I guess presumably could jump 6 feet. And so they were of the opinion that they should be granted a variance for an 8-foot fence because their dog can jump 6 feet. Well, unfortunately, that's a personal circumstance, and I'm sorry that your dog can jump 6 feet, but that doesn't quite meet the criteria for issuance of a variance.
What if it's a service dog?
Well, I mean, yes, it could, maybe.
ACA comes into
Yeah,
it.
yeah,
PDA comes into effect.
Yeah.
Impact them, yeah.
yeah. I wasn't the one to be able to, I had just offered that she could read the statute and come to her own conclusions, but. Number 3, so number 2 and number 3 are really the difficult criteria to meet. The hardship did not result from actions taken by the applicant or the property owner. And the act of purchasing, and that's really, number 3 is, the first sentence is the one that often comes up. Second sentence, the act of purchasing a property with knowledge that circumstances that exist that may justify the granting of a variance is not a self-created hardship. And so that does come up from time to time. I'm going to buy, you can think about, particularly with coastal real estate, you may buy a property that's on a small lot, or it's got an odd configuration, and you may need to have some type of relaxation of the setbacks in order to build a structure. I can buy that property knowing that I may need to get, in fact, a variance to build something. And that does not mean that I'm in violation of this criteria. Yes, ma'am.
Does the property owner, whoever owns the property, they know that this has something that's they need a variance for it? Do they have any, do they have to take any steps beyond just, oh, I know it, I'm gonna ask for a variance? Do they have to look to find a way to solve the problem before coming and asking for an excuse?
That's a good question. I think typically, and this is an anecdotal experience. People do not want to have to come ask for a variance usually. It's in most cases, although it may not seem that way, it's one of their last resorts. But no, technically you can apply for the variance if you meet the terms of the ordinance. If you got an oddly configured lot, maybe you could build a house that looks like a piece of apple pie. But if you feel like, you've got some reason that actually I would like a rectangle house because I've got, this oddly shaped lot, and I can meet the rest of the criteria, then I can come apply. Does that help answer the question?
Well, I just kind of think, I've, in my short amount of time, have seen several discussions where the people have looked at multiple builders and yet they haven't done anything about deviating from their basic box house. they've just asked for a variance on setbacks.
Yeah.
I mean, I think this is saying, isn't it, that they don't get any special consideration. They just don't, they're not penalized
Right.
because there was already a condition that required a variance on the property.
Correct.
So, I mean, they still have to meet whatever the other criteria are for a variance, and if they don't get it.
So don't buy a property with the assumption that you can get a variance to do what you want to do.
Right, but at the same time, say I own that property and I want to sell it to someone else, I shouldn't be limited by you as a purchaser precluding you from being able to go apply for that variance, right? Because if that provision said, well, you know, or the board said, well, you should have known that you shouldn't have bought that property because you're going to have to get a variance. You know, you have rendered potentially the property unbuildable by virtue of that fact, right? Does that make sense? It doesn't matter who the owner is necessarily, so long as that piece of property meets the criteria, there's probably justification for them to apply for that variance and potentially it be granted subject to the meeting of the other requirements. Is that, I don't know if I explained it correctly, yeah. Now, look, if it is an oddly shaped lot, but I want a higher building, for example, or higher structure, you know, maybe that's something different. And I don't know that that actually would meet the criteria.
Well, you know, I mean, you can think of an example of, if it's an oddly shaped lot because you sold part of the lot off to your neighbor, then that's of your own creation, and that's your own fault.
There you go.
But if it's an oddly shaped lot from the get-go, then that's a different situation. So it's a different kind of characterization of whether it's of your own making, of your own creation, or of something that's already existing. And I think all this is saying, if it's already existing, you have the same chance as everybody else, even if you bought it from somebody else with it already existing.
Yep. The requested variance is consistent with, and number 4, the requested variance is consistent with the spirit, purpose, and intent of the regulations such that public safety is secured and substantial justice is achieved. And this provision is really basically says that, look, if there is a front setback of whatever, 10 feet, and say you want to grant a variance for 6, 7, 8, whatever it may be, that's, you know, you're modifying the terms. But if the applicant comes in and says, I want 0 setbacks, I want to go from 10 to 0, maybe that's not quite consistent with the purpose of the rule, and maybe, in fact, instead of varying the terms of the ordinance, you're rewriting it. And in that case, maybe a text amendment is more appropriate, and that it should be under the purview of the legislative body to issue that decision, rather than rewrite the law entirely. Does that make sense? Number 2 and number 3 are the ones that are difficult to overcome for most people. You are not allowed to request for a change in the permitted uses, and the Board of Adjustment separately may attach appropriate conditions to the issuance of any variance. I would seek some advice from staff and the board's attorney before you were to attach any of those conditions to the issuance of a variance.
I've noticed as of late, at least once or twice, the American Disabilities Act came into play to grant a variance, and that seemed to trump everything when that happened.
Yeah, I don't know. I don't have necessarily a good answer for you. I will say that it has been used fairly commonly, particularly in our beach communities, for where our lots are so small already, and you're built to the extent of your setbacks, and if you need an elevator or a lift-evator or some other mechanism, yeah, So, yes,
Here's the doctor's note.
That's happened, what, at least twice?
Yeah.
Since we've been here?
Yeah.
And one of the, I mean, we had, the last one that we did was for a shed roof that extended into the setback. And it was to provide shelter for a golf cart that was used by a woman with disabilities. And so we granted the variance, but we wanted to put a condition on it that could stay only so long as the woman with the disability was inhabiting the home.
It didn't run with the property forever.
Right.
Correct.
And so that's a kind of a condition, I don't know, I mean, it was kind of felt kind of a little iffy when we did it.
yep.
And I don't know whether you've seen any time-limited variances of that variety before? Or,
Usually with time limits, it needs to be in regards to something different, like, hours of operation. Because typically, we're not supposed to get into regulating ownership for zoning purposes. So usually if you're going to grant a variance, maybe it's time limited, but it is not based upon who the owner is. And so, I mean, I guess I'm trying to think of an example where, maybe someone had to put up a bulkhead or a temporary fence for some period of time until something or other was established. But, that has a strict time limit on it, and regardless if the property sells or not.
but I think it's gonna come up
It
more
may.
often in the case of these ADA variants, because, I mean, they're, very often you can see a
Yep.
situation where in order to comply with ADA requirements or to provide that benefit, it makes sense.
Right.
But not necessarily for the long term or for everyone that would ever live in that.
Yep. I mean, I guess from my perspective, this is me, Wes, not Brady, not Brian Eads or anyone else. I would say that if you believe that it was okay to grant, I would think of it in a way that, one, from an enforcement standpoint, the town's not going to be digging through, deed records. The property's changed hands, or so-and-so's no longer there, or whatever it may be. So, it's unlikely that they're going to show up on the doorstep with a violation notice. Secondarily, if I am the new owner and I got that violation notice, I may go to the statutes and realize that, well, zoning is supposed to run with the land and not subject to the owner. And so I don't know that that's a valid violation. But, sorry, and then, I don't mean to interject, but more from a practical standpoint, I mean, if there is justification to grant it in the first place, I would just think of it as though it's probably okay to be there in perpetuity.
If
For
it's an
whoever the
attached
new-
permanent structure like an elevator that encroaches and it lets that back, then how can you say that it has to be removed?
Right, I mean,
Yeah.
and certainly there's a difference in kind between an elevator and a shed roof, for example.
It's a conundrum in
Yeah.
many ways.
It is a conundrum because you're referencing a federal statute, but we're under the guise of our state regulated statutes for zoning. So I don't have a good answer for you.
Right,
And then I don't know if you do this, you're not required to do it, but I recommend that the board vote on each of the 4 provisions as you go. All right. You guys are doing great. I know this is a lot of material. All right, we'll talk specifically about quasi-judicial procedures as they're outlined in statute. Your quorum depends on your local ordinance. It's simple majority, or in some cases, 4/5. Voting for a variance requires 4/5 majority to grant a variance. simple majority to issue a special use permit or affirm or deny an appeal. Vacant seats and disqualified members are not considered members for determining majority where qualified alternates are not available. The hearing, it's an evidentiary hearing to gather facts, not public opinion. If it's a legislative hearing, remember, for a legislative decision, we can listen to public opinion all day long, but not for these hearings. A detailed record of the hearing is required, including detailed minutes or preferably verbatim transcripts or recordings. If you have multiple cases on one agenda, the hearing for each case must be opened and closed. Witnesses. Evidence must be presented under oath and cross-examination must be allowed. The BOA chair may subpoena witnesses, and the chair or clerk to the board may administer oaths. The subpoena witnesses thing has never occurred. I don't, but it is permitted. Lisa will administer the oaths, depending on how you handle it. I usually recommend that anyone that even thinks they're possibly going to want to speak at the start of the hearing, come on up and have the oath administered so that's all taken care of. Findings. Written findings of fact are required. Where there is conflicting evidence, the board must specify what it determines to be the facts that are the basis for the decision. That I would say is sometimes, typically rare. I've only encountered this on a handful of occasions, where, for example, you have two different engineers with telling you two different things. But typically, that doesn't come up. Okay, conflict of interest. The North Carolina Constitution gives parties to quasi-judicial decisions the right to an impartial decision maker, so conflict of interest must be avoided. All meetings and all deliberations must be open to the public, but deliberations and decision may be separate from the hearing. The key with this, does that mean that you guys can go into closed session? No. That just means that you can close the hearing portion of it and you can no longer take any testimony if you want. It's usually not necessarily good reason to do that. You guys may be discussing or deliberating and someone wants to clarify a point in the record or whatever it may be, in which case if you've closed the hearing, then you got to open back up and then hear them. So, but you're allowed to do that. If it's a particularly contentious one, for example, you can say, we're done. We're done listening to what you got to say for now.
This raises the question, it's an open meeting, does the Board of Adjustment ever go into closed session?
Nope. Yep.
Nor can they discuss the facts before the start of the hearing.
Correct. Yep. I'm not going to speak for, the BOA attorney, but there are limited instances in which closed session is permitted, and 99.9% of those are under the purview of the town council. Okay, quasi-judicial procedures, continuing. Evidence must be substantial, competent, and material, and must be entered into the record and kept on file. Hearsay and non-expert testimony cannot be the basis for a decision or for establishing a fact. Board members may not gather evidence outside of the hearing, and ex parte communication is not allowed. Only evidence presented at the hearing and subject to cross-examination should be considered. That is a whole lot of information there. So ex parte communication effectively means that you are discussing the case outside of the hearing. And so that's a no-no. I think you guys all know that. If someone comes up to you outside of the hearing, in advance of the hearing, or it's a neighbor and you know them, and they want to talk to you about the case, respectfully tell them that you're not permitted to do so, and if they have questions, please contact staff or attend the meeting. And that's it. You know, if you happen to slip up and say anything about the case at all, be sure to disclose that at the start of the meeting. And we talked about this earlier, but, you know, you guys should not go on to, you know, Google detective search about whoever the applicant is or the request, you know, because naturally it may impact your impartiality. You know, you Google the person's name and, oh gosh, they've bankrupted a small town in Florida. They're gonna, you know, destroy our town. Well, what if that's actually someone has the same name and it's not actually that person, and you're walking in the door knowing that whatever they want to do, I'm not allowing it. So, you know, for that reason, you should not be gathering evidence outside of the hearing. And, you know, the true reason is that the appellant or the applicant doesn't have the benefit of sitting there over your shoulder to see what it is that you're, you know, looking at. Okay, the term competent evidence, and this is in statute, shall not include the opinion testimony of lay witnesses as to any of the following. The use of a property in a particular way affects the value of other property. But I saw it on Zillow, and I'm certain that if that's built, then, you know, my property value is going to go down. Well, that's wonderful. Are you an appraiser? The increase in vehicular traffic resulting from a proposed development poses a danger to the public safety. That's a big one. And then, you know, matters about which only expert testimony would generally be admissible under the rules of evidence. You know, I don't think you guys have had to experience a lot of this. This is typically more so for a special use permit, where the neighbors show up en masse with pitchforks and everything's going to be ruined and so on and so forth. And that doesn't discount the fact that, you know, they're upset about these things. That's okay, but you guys just can't take into account the fact that they're upset and that they're providing this testimony.
We're not to be lobbied.
Correct. Yeah, that's the job of the town council.
Which is interesting, because the job of the council people are to be lobbied by their constituents, and the council people presently hear the special use permits, and they don't really understand what quasi-judicial is.
Well, yes, that's why also across our region, I offer that sometimes special use permits are maybe not best suited to be in the hands of our elected boards. But yes, lobby all day long for a legislative decision, but not a quasi-judicial decision. Trial court rules of evidence are not required. Okay, we've talked about this. I'll hit on it one last time here. Members are disqualified from participating, not just from voting, in the following situations. You have a fixed opinion prior to the hearing, and there's undisclosed ex parte communication, discussion regarding the case outside of the hearing. These second two items are conflict of interest provisions that apply also to the planning board. Planning board is not subject to the first two, however. That there's a close family, business, or other relationship with an affected person, that could be spouse, parent, etc., or there's a financial interest in the outcome. If there's an objection raised and a member refuses to recuse, the rest of the board votes on the recusal.
I don't think that's ever actually happened.
Good. That's good. Remember, you guys are bound here and you're here for a duty to hear these hearings and vote on them. And so if in fact you've got a conflict, absolutely you should recuse yourself. But if you don't, really you need to be here to hear that case. And I'll say that the financial interest in the outcome, that's very black and white. That, if there's a question of that, if there's a question of any of these, I will say that you need to send first your concern to Brady, and he'll cycle it up the ladder to legal counsel to get some further information interpretation whether you have a conflict. So, the one that comes up all the time, and I don't, you're a realtor on the same realtor team, and there happens to be a realtor or someone here that's applying for a variance or some other thing. That's, you don't have a financial interest in that outcome. I mean, if you're a general partner on a development proposal and the other GP is here and they're applying for a variance, then yes, you probably have a financial interest in that case. But I mean, it needs to be pretty crystal clear. We've talked about this a little bit. Parties and witnesses. Parties with standing have rights to present evidence, cross-examine, inspect documents, and object to testimony and evidence, and offer explanations or rebuttal. An attorney may present a party and act on the party's behalf. Based on an ethics opinion from the NC State Bar, non-lawyers may not provide legal advocacy on behalf of a party. This is a difficult one sometimes, especially in our smaller local governments, where a contractor, for example, may want to apply, or a surveyor may want to apply for a variance, or some other quasi-judicial matter on behalf of their client. That individual can be present and provide testimony as an expert witness or just to provide general testimony, but they should not be the one that's there to present the reasons why they meet that criteria for the variance. Does that make sense? Well, here's the provision on that. Architects, engineers, surveyors, and other land use professionals can participate as witnesses and provide evidence in support of their clients, but they cannot cross-examine, make legal arguments, or examine evidence. All right, we are moving right along. As I stated prior, findings and facts and conclusions of law are all reduced to writing. These are just some examples, and these are prepared by staff and or legal counsel. Section 12.5A of the zoning ordinance required a 15-foot side yard setback in the R10 zoning district when the structure was constructed. That's a fact. And then in conclusions of law, I'll just say the second one, the hardship is not the result of site characteristics, but is common to all commercial property in the neighborhood. That conclusion would be based on some evidence that presented as simple as showing, okay, in a commercial court, all the lots are 5,000 square feet. They're all the same exact elevation, and your lot is no different than anyone else's. And there's the conclusion there of law based on the fact that was presented. It's a very simple one. Okay, considerations for these items. They must be in writing. They must be signed by the chair or another authorized member. And they must explain the logic, or they hopefully explain the logic behind the decision. Because remember, your decision that you make here can be appealed to Superior Court. Who will prepare them? Typically, staff or the attorney. When will they be prepared? Typically within a few days of the hearing, or a week or two, just depends. And when are they approved? Most places they're approved upon chair signature. Is that the case here? Okay. Yep. Rather than having to hold a whole separate meeting again to approve them. Yep. Okay. talk a little bit about this. How should non-expert testimony be handled? It must be ruled on by the chair. It typically can be heard but cannot be the basis of the decision. In some of our places, some of our local governments, especially for special use permits now, they have a whole diatribe at the start of the hearing about what standing is and who can provide testimony and participate, to attempt to quell some of the testimony that occurs. Unless it's really contentious, I usually say it's fine to listen to whatever it is someone wants to say, but you guys just know that you can't take into account testimony that's not supported by fact or evidence, right? And especially if it's someone that doesn't necessarily have standing. How should standing be determined? Must be ruled on by the chair or the board and not staff. So that's another thing that comes up. If I want to, appeal the issuance of that permit over on the ocean front and I live in Wilmington and I tell Brady that, he's got to let that proceed. And then ultimately at the start of that hearing, hopefully it would have been called out or flagged in the staff report that we're not so sure that Wes has standing or the right to appeal the issuance of that permit. And that'd be the first item on the agenda.
Who can bring up the issue of standing? Is that something that the staff could alert the board to?
Yep. And I mean, just know that there'll be conversations that are had, but we can't stop somebody from applying for something if they want to apply for it.
Right.
Time limits are generally not permitted. It's routine for public comment or public hearing. You got 3 minutes, not for this. All right. You guys have been through this before, and I think this is similar to your hearing process, but forgive me if it's not. This is just an example. The chair opens the hearing and announces the case. Witnesses are sworn in. Staff gives a summary overview of the case. The appellant or the attorney presents the case, documents, evidence, etc. BOA may ask questions, and the chair allows cross-examination. The objectors present their case, documents, etc. BOA may ask questions. The applicants may rebut to anything that the objectors had to say. And similarly, the objectors may rebut to the applicant's rebuttal. Hopefully everyone's done speaking their piece, at which point in time the chair and the rest of the board can summarize evidence and exclude hearsay and opinion testimony. And the BOA may add or clarify. All parties may offer objections, corrections, or additions to the chair's summary of evidence, or, you can insert board summary of evidence, you all's discussion on the matter. There's a deliberation and determination of the facts and conclusions. There's a motion and vote, and the hearing is closed. And it would be delightful if things went so routinely, but I would be mistaken if I said otherwise. I mean, these things typically have a way in which they go down some rabbit hole that you couldn't possibly have anticipated, and that's just the nature of these hearings. Questions about that? I've got a couple sample questions, and then we're almost finished up, and I appreciate everyone's time. All right. Yes, sir.
Go on to the one.
Yep.
Outside evidence, and we didn't talk about site visits and the wisdom or lack of wisdom of site visits.
Thank you, Steve. That's a great point. So, Oak Island, depending on where you live here on the island, it's not too large of a place, so it's entirely possible or likely that you will be passing by a property that is going to be subject of a variance hearing or an appeal hearing. So is it okay for you to stop by or visit the site? There is not a black or white yes or no to it. Yes, you may stop by. And by meaning stop by, that's probably drive by, most likely maybe not get out of your vehicle and start walking around the site. Most certainly not, get out and go start talking to the property owner or whoever it may be that is presenting the case. Now, what happens if you also see something that strikes you as odd or peculiar? Should you share that information at the start of the hearing? Yes. Because say you stopped by and you saw something that seemed odd or unique or something that has impacted your impartiality or your opinion, maybe there's good reason for that, and so you should share that at the start of the hearing. The applicant can have an opportunity to say, well, that was there for 5 minutes on Wednesday for this, that, or the other. I don't know, but
You may not talk with the property owners.
No.
Absolutely not.
absolutely
But
not.
For a member to go and look at it, I feel it's good because the photos don't exactly show what it really looks like when you're standing there. For that reason, you just say, yeah, I looked at it, I was there.
But it is.
Mark Snicks.
It is in fact gathering evidence outside of the hearing.
It is.
That's
That's a fine line, isn't it?
It is a very fine line, yes.
and often significant evidence, actually. Evidence that you wouldn't otherwise know based on what you're presented by both the staff and the applicant.
So, yeah, and so I think it's prudent that you disclose, what you saw or noticed or whatever it may be, and in fact that you did go to the site. And I would remember when you went there, too. But that's a great point. I think in most instances, we do have members that that they're going to drive by the site at some point. Don't start walking across the property. I don't think that that's a very good idea. And, remember that you should not be gathering evidence. If you feel like it is helpful for you to be prepared, perhaps that's one thing. But yeah, I mean, if it's helping you to lead yourself in some type of decision, you happen to show up and you notice, oh, I know the neighbors over there next door. They're really not going to like this request to allow a reduction in the setback on their side, or to build this house that's going to block their view, or whatever it may be. So just keep that in mind. Is that, Steve? You're welcome to provide any other comments to that effect, because that's a tricky one.
Yeah, I mean, it's just, I mean, I don't think I've ever made a site visit where I haven't seen something that wasn't presented as evidence, in the hearing. And it can't help but influence,
Your opinion.
yeah, the decision, And yet, it seems to me that if you don't do that, that you're not providing the best service to the community. If you're making a decision that leaves out a significant part of the evidence that you ought to have.
Yep.
It's an interesting point. It would you'd almost have to do a survey amongst the board as to what did you gather from this visit that wasn't presented by the board.
Yeah.
by the
Yeah,
staff,
but
and at
the
some
board
point.
can't present evidence.
No, none of what I meant was the staff. I said board. I
Staff
misspoke.
can, yeah.
And then in that case, the negatives outweigh the positives for a site visit. And you know,
Yeah.
it's a toss-up.
Well, it potentially leaves us open to being overturned on an appeal. That would be a bad look. A very bad look.
Yeah. So I would just say, be mindful of this training and the fact that your opinion may be swayed by that visit, and be mindful to provide and disclose that you went to the site and anything that you saw that came to mind.
Yeah, help to avoid it.
Yep.
Yeah, but you unknowingly, oftentimes, like you say, make a site visit. If that is the case, I drove by this house last week. Should I basically submit that information before the hearing starts?
Not necessarily before I think that unless I'm mistaken, Lisa and Brady, assuming Brian still is here for these, he usually asks a question if anyone visits the site.
Does
Okay,
every time.
There you go.
Right when we open up.
perfect. So if you say no and you did visit the site, then that's problematic. But yes, and if it is a contentious case and they're represented, then that offers their attorney the chance to ask you specific questions about when you went there, what you saw, all these things. And so,
You turn into a witness and not a member of the board all of a sudden.
right, but that's part of their due process rights, and usually it doesn't come to that, but it's at least been disclosed.
Guess maybe that's part of the quasi and the quasi judicial.
Yeah. So I've got a question. We get the packet, and it references in at least one case, the applicant has referenced certain court decisions because she had an attorney, didn't bring him, but had an attorney and said, no, this is my conclusion. We allowed to go read those?
That's probably, but
They brought it in, but they
Sure.
didn't bring the court decision in.
but you guys aren't necessarily attorneys. I mean, I would say that I think that you should just look at the merits of whatever their case is. If they're going to appeal your decision regardless, then let them deal with that at the superior court level based on case law.
Another case, that
Yeah.
she referenced deeds. We allowed to go look at the deeds?
Probably. Yep. I don't know what that instance would have been, but, they probably should have included the deed in
There were
their
deed
applications.
restrictions. There were deed restrictions.
There are deed restrictions, yep. That's another tricky one because the local government doesn't necessarily, we do not regulate deed restrictions, but they can sometimes impact the zoning setbacks that are limiting. And so that's a tricky one. And so for that, in that particular instance, it's possible that the zoning setbacks may need to be taken into account based on a restriction to that particular property.
Well, maybe another way around that is when they're up there saying, because of my deed restrictions, enter the deed restrictions into the records.
Yes.
Ask that.
Yeah.
References an appellate court decision. Enter it into the evidence. We'd like to look at it.
Yep. I think that's fair. Yes, sir.
Probably a better way to do it.
Piggybacking off of that one, so we'd like to have those pieces of evidence, and we all agree we want those pieces of evidence. Do we then stop the hearing at that point and say, let's sidebar it for right now, let's table it, put it for the next month until we get to see it, or is that something that stops us right in our tracks until we get that information right then and
So,
there?
first question I think would be to raise that question to the board's attorney. I think would be first. If it's relevant and impactful to your final decision, then there is a way that, you know, certainly the meeting can be tabled to a future date. In some instances, it may be, and I have unfortunately been privy to one of these meetings. It was almost 30 hours long, but, you know, that is rare. So usually, there's not necessarily good enough reason to do that. But yeah, you would hope that they would have included in this case, the deed in the application file. Okay. Well,
It's easy enough to look up a deed.
yeah,
I mean, it's
Yeah.
just right there.
yeah.
Does the board have any further questions for Mr. McLeod?
Well, yeah, I have a question for you, but not necessarily. We can.
Okay. We've had couple quick questions and then get you guys out of here, and I appreciate everyone's patience. Your board is considering a variance petition. A neighbor appears at the hearing and presents a petition signed by 50 other neighbors opposing the variance. Can the board consider the petition?
How close does that neighbor live?
That's a good question.
If it's next door, they can talk. And generally Brady always gets everybody around the property. 50 other neighbors, I don't care.
So you sort of hit on it. The board cannot consider the petition to be evidence because the relevant matters to consider are the facts of the case and whether request meets the ordinance requirements for a variance. Maybe that neighbor does have standing and they can provide testimony based on why the variance doesn't meet the terms, but it doesn't matter at all what the other neighbors have to say, unless that was a legislative decision, for example, and it was a rezoning. Fine, you can take that into account. Your board is considering a variance petition. It will cost an extra $3,000 in construction costs in order to get a driveway in, avoid some wetlands on the site, and still meet the setback requirements. So a setback variance is requested that would reduce those costs to $1,000.
That's enough.
I don't think so.
Yep, that's right. Simply because it will cost money in order to meet ordinance requirements. It is not a hardship. The cost of the lot could have been reduced by $3,000 to make up for the fact that it was going to cost more to develop the property. Pecuniary hardship is not supported by case law or hardships based on the fact that you're going to have to spend more money to do X, Y, or Z. That's it. Last two. Thank you all so much.
Thanks, Wes.
Thank you very much, Mr. West. Oh, one last question before we adjourn. Mr. Golden, we had on schedule a variance coming up and somehow somebody came to terms. Can you give us a little background on how that conundrum was
Close
avoided?
out before we get into that.
Say again?
Yeah, not as a board.
Just close
This is
our
not an
meeting.
official meeting, so let's not have any board
Oh,
discussion.
Can you share something on that?
Well, if you want to talk to me individually
Yeah,
afterwards,
okay,
absolutely.
thank you.
For sure.
I'm assuming you're saying it's adjourned?
We are adjourned, sir.
Thank you.